to mention item number 26, madam. We can leave password for the day. 26.
You're not passing any order at this stage. Mr. Sarkar, it's a 2017 matter.
Yes, madam.
Okay, ask someone to be here. To pass the order, not at this stage.
May I please, Your Lordship, I beg to mention for listing of the IA Lordship, it is urgent Lordship, for modification of the order Lordship. It may post on 19 Lordship.
What is the urgency?
Urgency means Lordship, it is transfer of the appellant should be effect on the date of 29 to 24. Instead of that, it is
Why before dispense? Transfer matter?
earlier honorable court has division bench 2 has passed.
In non-availability of division bench 1 or for some other reason? Otherwise,
Might be non-availability.
This is a regular appeal.
this
You are-
is
you'll go-
special bench is an FT. Only in the absence of the regular division bench or one of the judge sitting in that particular bench cannot take up. That's why it might come to bench 2.
Lordship has passed this order.
No, that is the reason. It will have to come to the appropriate bench. You first get the approval from the registry in the bench section, then you see.
Lordship, please.
Maybe the lordship's item number 11, lordship.
Hmm.
The password for day, lordship. Motion, madam.
On the prayer of the council for the petitioner, Mr. Rain Ahmed. Then for a week. Yes, next.
May please, your lordship, my lords, I beg to mention item number 34, 36, and 37, your lordship. May kindly be adjourned, your lordship, because of some personal difficulties here today, your lordship. 34, 36, and 37.
Okay, let the matter reach all our 2018 matters.
18 matters.
Let the matter reach.
Obviously.
May I please, I beg to mention item number 20, my lord, on behalf of AK Tapadan, AS Tapadan. Kindly adjourn this matter for the day only, my lord.
Let the matter reach.
I beg to mention item number 38, Lordship. In this case, we need 1 week's time to obtain some instructions, Lordship. For the appellant, Lordship.
All of the petitioners are not agreed.
Lordship,
How many petitioners are there in the petition?
four appellants, maybe, Lordship.
How many petitioners were there in the writ petition?
If I'm sorry, I do not
There
have
were
the brief
6 writ
presently.
petitioners and the appellant is by 3. All of you have not come.
The prayer for the council for the appellant. Matter is adjourned.
Obliged, Lordship.
We'll take up the cases first where there is no LCR. Wherever there is LCR, we get it and it will get up. So we'll accordingly call it. Number one.
Make his lordship,
Just a
lordship on
By our order, earlier order is the 0802/2024. We direct the concerned authority of the registry as to when the order is at 11/11/2003 in WPC number 7093 of 2003 was communicated to the parties concerned. Fixing the matter today. However, though this petition has been listed today in pursuant to the order dated 8/2/2024 noted above. We did not find any report from the concerned registry regarding the date of communication of the order dated 11/11/2003 in said WPC number 7093. The registered judicial after making necessary inquiry shall submit a detailed report why this matter has been listed today without such report that we had sought for by our order dated 8/2/2024. Moreover, the registered judicial shall also apprise the court in its report. Apprise report. As to when. We ordered it at 11/11/2003. First in WPC number 7093 of 2003 was communicated. The concern for it as tribal. Concern. Appellate tribe. Based on.
Bless you.
Give 7.
Made please, your lordship. Yes, here we have. Not piece of over piece.
Where is the link document?
My lord,
Link document annexer
Page,
12, my lord.
page.
Page, my lord, I am giving. Page 41,
How this document was proved?
my lord, one person, my lord.
Hmm.
Uh, It was exhibited, my lord, but possibly it is not proved.
Why? It was not proved. Then how you have proved? If you have not proved, then it's not proved under section 9 of the Foreigners Act.
No, my lord, now next document, my lord,
Hmm.
a Jomabandi copy
Hmm.
that was proved by Mondal.
Where is it?
Page,
No, maybe, but how you have proved your linkage?
my lord.
First of all, you have to prove your linkage to show that you are daughter, son of somebody
My lord,
who has some land property somewhere.
my
Where
lord,
is it?
my lord.
How you have proved that linkage? First, you have to show us.
That linkage certificate has been exhibited, my lord, that is not proof.
If it is not proved, then linkage, if the linkage hasn't been proved, how the land document will come to your aid?
Evidence has been given, my lord, this
Hmm.
neighbor and this
That will not do.
DW3.
First of all, that the proceeding is son or daughter of somebody has to be proved by something.
My lord,
By which document you have proved that?
my lord. So in that case, my lord, let me pray for some time, my lord.
Why? If it is after a week, after a month, will it help you?
My lord, let us see, my lord.
How will you prove? That's the reason we are asking at the very first instance, what is the link document?
My lord. My lord, in that case, my lord, I am to obtain instruction from my party, my lord. So after 7 days like this, my lord.
say it's an interpreter order.
My lord.
It's an interpreter order.
Yes, my
You had contested.
My
What
lord.
is the date of the order?
Yeah.
22nd of September 2020.
My lord.
When did you apply for certified copy? You applied for certified copy on 8/12/2023
Yes, my lord.
after 3 years. And you have filed this in 2024. Are you really interested in challenging this?
My lord, definitely, my lord.
Definitely, you
Well,
don't
that,
say bona fide on your part. You
My lord, regarding this delay, my lord.
have not stated anything where you are a poor person, that is all.
Well-
You have stated that you are a poor person.
Yes, my lord. Poor and illiterate person, my lord. So, my lord, regarding this, my lord, the limitation. That,
No, we are not on limitation, we are the issue of latches, it's not a question of delay.
my lord,
We are jurisdiction, equitable jurisdiction.
my lord. My lord, in that case, my lord, my reply will be before your lordship. That petitioner is totally. Sorry. The petitioner is totally illiterate person, my lord. Poor, not only poor, but illiterate. And they have not taken it that there will be problem if there is delay, my lord. So, my lord,
Say,
it's a question of citizenship involved, my lord.
that is why you
My
should have
lord.
come at the earliest. Next day you should have come,
My lord,
next month,
my lord,
same year.
my lord,
No, year.
my lord.
You apply for the certified copy after 3 years.
My lord.
You have serious doubts on your,
My lord, thing is this, my lord. I am before your lordship as an advocate to represent my client who is totally illiterate. And what question put by your lordship on the other side? I also put this and
exactly.
answer is not there. But thing is this, my lord, they are only illiterate person and they are not so much alert about their right, what is dangerous.
Sake.
As
It's a
a
sake.
judgment has been passed
Sake,
against them.
sake. This is a very
Implication,
important issue.
my lord.
Will not, definitely not preclude you from entertaining, but as an equitable court,
My
we
lord.
definitely ask you why it is.
Definitely, my lord, it is a genuine question put by your lordship. We are also,
Maybe in spite of this,
My lord,
in a given case.
we are in between, my lord. Client is there, I am in this side and your lordship on the other side. But only thing I can place before your lordship as counsel of the petitioner that they are illiterate person. So your lordship would be pleased to examine the matter if there is anything. Keeping aside this lecture, for the interest of justice.
At times we come across expert orders, which
Hmm.
the procedure was not aware, then suddenly somebody comes informed. There may be, but here is the contest.
A contested case,
To apply for certified copy after 3 years.
my lord. But that limitation may not be taken into consideration, my lord. But matter may be taken after 7 days, my lord. Let me see why they have not proved this GP certificate, my lord. Linkage is the problem, my lord, but otherwise there is documents, my lord.
What is your age?
My lord.
Age. Not your age, petitioner's age.
Yeah, for that, my lord, for my age, I am not to look into the petition, my lord, but my client says is to be looked from the affidavit.
Yes, very much.
My lord. Mavaro Kali, aged about 55 years.
So in 2024, if he is 55 years, what will be his birth year?
Let us.
2024 minus 55, 1969.
1969.
You add 1969 plus
Hello.
18
69
or
plus
21.
69, possibly my lord, 69 plus 21.
Then
Because
this
from 80, 84, it is 80.
21, it will become 1990.
Yeah.
Right?
Yes, my lord.
If it is 1990,
Yes, 21,
in the year 2020, you became 21 years.
25 was the last. 24
The voting age of 18 came from March 1989,
My lord,
right?
yes,
So in the voter list of 1989, name of the petitioner should have been reflected.
my lord.
Then please come to page number 60.
24
Please come to page number 60
60, my lord.
of your written statement. Para 7.
Para 7. That the answering opposite party further begs to state that his name has enrolled in the voter list of 1997. So your lordship's question is this: why during this period in the voter list my name is
He
not?
was eligible in
My lord, My
1989.
lord, my reply will
This
be,
time the question
My
don't
lord,
say he's illiterate, he's poor.
my lord, no, illiterate, poor, I will not say my lord, but my humble submission before your lordship that voter list before 1970, my lord,
We are
or
not on
before 1971 is relevant for consideration of the citizenship. my lord. Subsequent voter list may enter or may not enter. That is not the main question. my lord. Your lordship pointed out that lately my name entered into it.
Yes.
Legally, my lord, legally, I will submit before your lordship on that count, my lord. It cannot be decided that your name is not entered into the voter list when you are eligible for about 10 years, 20 years. My answer will be that that is not the point.
When
Good
your
question,
father expired,
my lord.
when your father expired,
My lord, father, expiry of the father, my lord, your lordship would be pleased to see in the voter list, the written statement. my lord. Let me read the written statement. my lord. It starts from page 59. My lord, I have no hesitation before your lordships. After
See, you
going
have
through,
definitely
the so many cases, your lordship also examined so many cases. That actually, what is should be the pleading, my lord. In, at least, in foreigners case, my lord, this written statement is written very casually. Requirement is not looked into. Just a written statement is to file, my lord. Your lordship would be pleased to see para 4, that the answering opposite party further begs to state that his father's name has appeared in the year 1971 legacy data code number so and so. Answering opposite party begs to state that father of the opposite party, late Wazuddin. So, my lord, when the written statement was submitted, at that time he was no longer. Wazuddin, son of late Abu Sheikhs of village so and so, possessed a plot of annual Kraspatta land.
Not much in this.
we'll have a look at the record, Mr. Singh.
My lord, Yes,
will be in the motion stage,
my lord,
let the records come.
my lord. I'll be obliged, my lord, and your lordship would be pleased to give me certain protection, my lord.
After 4 years,
My lord, anyhow, my lord, as your lordship admitted to this. Considering all lapses, my lord. I will appear before the authority, my lord. Otherwise, my lord, there may be trouble.
we'll fix the
like-
date, we'll go for final disposal, we'll fix the date.
My lord,
Dissatisfied with the final order dated 22/12/2020. Pathway Limited Member Foreigners Tribunal Baksa. In application number 2395/Baksa/2016. Whereby he has been declared to be a foreigner under the Foreigners Act 1946. The petitioner has filed a said petition on 06/02/2024
happy as someone, my lord. Okay.
after more than 4 years. Before we proceed further, we propose to peruse the look into the record of said application number 2395/Baksa/2016 in order to call for the record of judgment from the office of the Minister of Justice. And lay this matter. on motion. This order record.
My lord, my appearance before the border,
Not at this stage.
my lord, oblige your lordship.
Mr. Sheikh.
My lord.
No. Fifth of March.
My lord, why I am submitting before your lordship, traveling your lordship? Because supposing, my lord, during pendency of the writ petition, I was put to jail. Again, I am to travel your lordship. As your
Will
lordship.
come on
taken-
5th of March.
My lord,
Please, your lordship.
Yes, Mr. Mad,
My lord,
link document.
page 24, my lord, answer 2, my lord. School transfer certificate, my lord.
School transfer certificate.
My lord.
When did you leave the school?
My lord, it seems that, my lord, 31/12/1982, my lord. 1982, my lord. She was in class
1982.
5, my lord.
When did you obtain this certificate?
This certificate was obtained, my lord, on 12/2/2020, my lord.
Just a minute, take your seat.
My lord.
Super.
High school. Secondary school. This school certificate is the only link document.
My lord, this is the only linked document, my lord. Regarding the, my lord, voter list, the petitioner's name was enlisted along with her husband, my lord, at her matrimonial hospital. Otherwise, regarding the linkage document, my lord, the school transfer certificate which was issued by the concerned headmaster of the school, my lord, and that was, my lord, also proved by the deposition, my lord,
By whom?
by the, my lord, one person, junior assistant of the school, who was authorized by the headmaster of the school, my lord. He came with all the necessary, my lord, documents, registered and everything, my lord. Page 64 is the deposition, my lord.
Let's see his deposition.
Yes, my lord. Page 64, annexure 13, my lord.
Junior assistant.
Junior assistant of the school, my lord. Same school, my lord. My lord.
Yes, sir. If you want.
The secondary school. It's a secondary school.
Yes, my lord, but
Can you study class 6 in a secondary school?
But I have been instructed by my client, my lord, that this school got provincialized in the 1981, my lord. If my lord necessary, my lord will only allow me some more time to get instruction. And before that, my lord, this school was established. They were imparting education right from class 1 to 6. My lord. After filing of this
No,
report,
you see, your certificate is dated when?
20,
20, my lord.
20. And when was the date when you had left the school?
82. no.
82, my lord.
And
It was
81
established in
was
81.
established.
My lord, regarding that part, my lord, that has been rightly mentioned in the my lord impugn order also, my lord. And regarding that part, my lord, I got the instruction from my client, my lord, that the school got provincialized in the 1983.
But it was established with 9 and 10, a secondary school. Forget the website information. We may not be influenced by website information. It's a secondary school.
Prior to that, my lord, yes, my lord, I got the instruction that, my lord, prior to that, the school was imparting education right from my lord, class 1, my lord.
It is a matter of instruction. Aren't you required to state in your, if you're relying on this document, that this document though is from a secondary school,
Yes, ma'am.
have you given any explanation in the written statement, evidence, nothing? First page of the register is not there. Junior assistant came, yes, okay, but first page
Yes.
of register is not there. Why? And this is the only document.
Apart from this, my lord, the deposition of DW2, he's the nephew of the my lord petitioner, my lord. His version is also there, my lord. My lord will find at page 12, 62, my lord, annexure 12. my lord.
We can review. One.
Shimma interim clerk may kindly be considered. Hello.
Item 9.
Maybe, Mrs. Miller, I have found that there are several mistakes in that. And also one lecture is wrongly taken. So I am allowed to with liberty to do the matter and help. That will happen.
Yes, Mr. Rashid, why do you want to withdraw?
But there is one annexer only will not take. Annexer will not,
Which annexure?
actually will not, annexer will not. Kill,
Annexure?
will not.
12 page.
Field will not 66. Last thing will not.
Yes.
Extremely the Gaugara is not, he is Gaugara Milan, Chitamon Bashmutari. But he was not examined. Examined was by another person, the Hazrat Ali. So this certificate was wrongly Milan annexed here. And on 2 or 3 Milan typical mistake is there, Milan in is correct.
You had many certificates at your disposal.
No, Milan, there is the 2 certificates there, Milan.
Why?
One was examined, another was not examined. And the person who was examined, Milan, their certificate is left, Milan.
He is
And
of which Gaon? Which Gaon?
that
which
is Milan,
village?
I also, his statement I have annexed, Milan, annexer PW 4 Milan, page 40.
40.
40, yes, my lord.
We'll have a look at the records.
That is, I'm sorry, Milan,
No,
actually,
records, we'll have a look. Why do, this we can, for the time being, ignore.
no, actually, my
Whatever is in
mistake.
the record, we'll not go beyond the record.
No, yeah, of course not. And when it will call me, Lord,
Neither you can introduce document, neither nor will allow the state to introduce document. It's on the basis of documents available before
No.
the record.
I am
before
only
because
responsible,
the
Lord, for
tribunal.
it is my mistake, Lord.
No, we can ignore this mistake. Who's this? Name Hazarat.
Hazrat Ali, he is on the Gaura Lord of
নাম ঠিকানা হচ্ছে
Panpara, where I am residing now.
এই সার্টিফিকেট কোনো উল্লেখ করেছে রাবি
T9 my lord. Yes, my lord.
Very good and wrong, very good. Nice. Huh? Exhibit 7.
Then it may come on Monday, my lord. I'll check it again, my lord. Otherwise, my lord, wrong submission, I may not be submitting your lordship.
Confidence.
I have annexed the next time, my lord, that is with of village Panpara, Gaura Panpara. T9 my lord, yes.
First paragraph.
My lord, I'm coming. My lord, yes.
Only the date is different.
There is a, my lord, I'll, anyway, my lord, it come on Monday, my lord. I'll try to submit you.
Date of the certificate is 9/5.
499, top 94, right top. That page
9/4/19.
67.
Yes, that is in vernacular lordship. I missed. Yes, I missed that. Yes.
Yes. Here is a 9/5. But this is wrongly rightly typed, my lord. But anyway, my lord, it come on Monday, my lord. I'll try to submit law.
State emblem. Yes, lordship.
But how can there be two Gaumburas in the same period?
No, earlier it is a father's place and one is my present place. That is the-
Panpara and Pakriguri building, sir.
Panpara was the, my lord, my father's place, my lord, where I was residing.
Agofunji,
And-
Pakriguri, Panpara and Pakriguri.
Pakriguri, my lord, there is the village, my lord, where I am residing at present, my lord. After marriage.
But reconcile. Pakriguri,
Record.
Thirty-three, 35, 36. 36 করতে এভাবে এক্সিবিট করতে আমি প্রতিদিন page 36 36 इसको आराम पहुंचे 30 30
And another also 2-3 typical mistakes is there, my lord. I mentioned, but
page 53
Rabia Khatun Reconnect shift in it. Please. Rabia Khatun Nur Bhanu. Twenty. No, it is too good. Rabia is nice. Where is the chief of your the proceeding?
Chief Milord. Proceeding, Milord, Chief, DW one Milord, page 22.
22.
Milord. Two.
See who's the deponent here?
I'm coming, Milord.
22.
Oh, 22, DW2 Milord, sorry, he is the Sukur Ali, he is the Milord.
Where is the proceeding? Where is the chief of the proceeding?
DW1 except 2 Milord. Case Chief Milord and page 20 Milord. Sorry, page
Page
20.
20 is the court question, perhaps.
Only there is a Milord. No,
There is no
chief.
chief examination.
No, chief. Only did the written statement and then he asked by the court. On oath, never registered a book. Not like these others also similar.
No. There are chief examination, which is followed by either court question or question by the.
Question by the AGP or government advocate. I've checked with that person. And DW2 Milord is the Milord cousin, brother.
Brother.
Cousin. And his cross Milord kindly see page 28. Superior is present.
Yes.
And here is also another mistake, Milord. Already I should mention, Milord. Structurally, age, Milord, you can type it as a 52 years. Wrongly, Milord, but it is 54 years. So, for all this, Milord, I am. Yes, 28. এটা আমার time থেকে অন্য কোথাও গিয়ে। তার next to document লেখা আছে। এখানে এই কাজ নাহলে ঘুরবে ওরা। And PW3 Milord is the DW3 is the mother.
Those who-
Records may be called for Lordship. Lordship is calling for the records.
Well, this is a contested case, my lord. Kindly see annexure, my lord. This is my lord annexure 6, page 48, my lord, improved order. My father name Joinuddin, mother's name is Jamirun Nisa, grandfather is Aharuddin, and grandmother name is Maimun Nisa. Name of my mother expired long time, my lord. Mother, brother appeared in 1977 after the cut-off date. And petitioner and mother 85. I also, my lord, got admitted in LP school, my lord, page 60 on there, and that was, my lord, examined by page 60. Your lordship. That headmaster was examined, my lord, that is annexure, my lord, DW 3, annexure 4, page 32. This headmaster, my lord. Secondarily. And another document is, my lord, my grandmother had land, my lord, and
Take a look at the record. Take a look at the record.
in direct production, my lord, can. My lord.
May please, your lordship. Lord, here the impugned order at page 62. My lord, this case, my lord, we have, apart of the merit, we have submission on the maintainability. The notice indicates, my lord, two charges that cannot be, my lord. In the Sunakha case, the Supreme Court has held that charge should be specific, not two. One specific, either in between 1166-71 or up 471. That cannot be two, my lord. Lordship may kindly have a look at page 25. Lordship may call for the record.
His lordship. Yes, lordship. It's a format. Yes, the photo. Post.
That's it. Correct, correct, correct. The comments will continue, yes.
Burden.
Correct, correct, that's it. It came later on, yes. Yes. No, we'll place it. We'll place- No, no, there was no, there was nothing was there. No. That. That has been clarified later on. Correct. Yes, that is correct. Doesn't say anything. Correct. Now later on. That will. Will.
Mr. Kolita, can you explain the meaning of what is the this notice, the first two lines at page 25?
Page 25 past 2 lines also.
যেহেতু ক্ষমতা সম্পন্ন
ক্ষমতা সম্পন্ন
কর্তৃপক্ষের দ্বারা সম্পূর্ণ
accord
না না প্লিজ রিড দি লাইন
আপোনাৰ বিৰুদ্ধে এনে এক প্ৰসংগ বা অভিযোগ উত্থাপিত হৈছে
যে আপুনি কোনো বৈধ নথিপত্ৰ নোহোৱাকৈ thereafter
25 মাৰ্চ বা 1971 1 জানুৱাৰী 1965 আৰু 24 মাৰ্চ 1971 এই সময়ছোৱাত
what is the meaning? He is trying to project or build up a case on this. What do you actually mean by this?
without any documentation.
No, this period.
Period is 25th March 1971.
No, there are 3 dates here. One is 25th March 1971, 1st January 1966, 24th March 1971. Which is that period?
So before, 1st January to 1st January 1966 to 24th March 1971. And after 25th March 1971, that's a different thing. So 25th March 1971 is one period because the stroke is there. Then 1 January 1966 to 24th March.
No, see the expression সময়ছোৱাৰ ভিতৰত. That means it is on the next one, next period, 66 to 24th March.
No, 25th March is 1971. That is one period.
No.
After 27.
Where it is written after?
That what is missing.
নোহোৱাকৈ 25 মাৰ্চ 1971, 1 জানুৱাৰী 1966 আৰু 24 মাৰ্চ 1971 এই সময়ছোৱাৰ ভিতৰত
অবৈধভাৱে অসমত প্ৰৱেশ কৰিছে। One is not 25th March 1971. Post.
No, where is the word post?
That word is.
Post is not there.
That word is.
If you say সময়ছোৱাৰ, that means within, it covers the second period. But if you are saying the period after 71, 25th March, that's a different. And he's trying to build up a case on that, projecting that. But to question, Mr. Sigdar would come, what is the prejudice you are suffering in defending your case? If you are a citizen, you prove you are a citizen.
No, my
Whether you are in between that period or
My
after 20.
the Supreme Court, my lord, in Sarvanda Sunal 1-2 case, my lord, in paragraph 50 says that in every stage, my lord, the proceedings should be fair and reasonable. This type of vague charge is also.
No, what is the prejudice you are suffering? If you are an Indian citizen, prove your documents.
That means, my lord, I want to say that this reference has been made without fairing investigation, without giving opportunity of defense at the investigation stage. Therefore, the vague charge.
That is enough. There cannot be a vague charge. It's only a word missing. And if he wants to try and build his case on this.
No, Mr. Sigdar will definitely
that
consider
cannot
your submission. But ultimately, the question of test of prejudice will come.
My lord,
Suppose you make out
lord.
suppose we accept what you have said for a time being, that the initial investigation was not very proper. They were not even aware whether you are in between 66 to 71 or after 71. So both has been said. So it means that the first investigation was not done in a proper manner, giving you adequate opportunity. But will that preclude you from defending your case before the tribunal? Ultimately, the adjudication process is before the
Malad.
tribunal, not before the investigation.
My concern is that, Malad, in every stage, right from the beginning of the investigation, everything should
Can you
be,
show us that part?
my lord, in the WS, my lord,
No, no,
that
no,
allegation is there.
no, in Sarvananda Sonal, that. part.
Sarvanta Sundar, sorry, my lord, I have not with the judgment. Paragraph 50. Paragraph 50 and 60 also. 50 said that every my lord, the
No,
proceeding
no,
should
that is
be
okay.
fair and
Let
reasonable.
us examine.
And 60 says that,
Fair and reasonable has to be construed from the context of your defense, whether you have been prevented by any means in reasonably
lord.
defending your case,
My lord,
or
that has been,
was a fair opportunity given to
that has
you.
been better clarified in Muslim Mandal's case in paragraph 97. What is called fair investigation, that has been defined, has been clarified in paragraph 97 of Muslim Mandal.
97.
My lord, the border police is to test him out by visiting his residence, in interaction or interrogation in presence of elderly persons, then taking his signature or thumb after interrogation. Well, these are the, my lord, the procedure has been, my lord, explained in the paragraph 97 of the Muslim Mandal. And therefore, in paragraph 98 also said, the reference cannot be mechanical. My lord, in this case, my lord, the plea of the petitioner is that basically the reference was made without fair investigation. That was the basic plea in paragraph 2 of the WS.
But only because the printed form has a little bit of lacuna, can that be a ground? You have to show that you are precluded
lord,
from
no.
defending your case properly, or you're not given a fair chance in the adjudication process.
My lord,
Investigation is not
investigation stage, the Honorable Supreme Court and the full bench judgment said that there shall be a protection during investigation stage, so that unnecessary case is not made out. My lord, Sarvananda Sonal 2, my lord.
Two.
2007 1 SCC 174. I don't know, government.
These things have been already clarified and settled in many of the cases, Lordship. These things have been already discussed many times, and these things have been already settled.
My lord,
Now again, these things have been.
not properly discussed, my lord. My lord, the Foreigners Tribunal Order 1964, in clause 3, there is a clarification, my lord, a specific mention that there shall be, notice shall be with main grounds. So, my lord, simply that you are foreigner, I think that is not sufficient in terms of clause 3 of the Foreigners Tribunal Order 1964. There shall be some indication. These are the grounds. These are the main grounds of charge against you. So, my lord, if there is judgment, my lordship is saying, my lord, I think that judgment is not in correct analysis. That well, we should go
No,
through
Mr.
that.
Sigdarthi, let us assume that's a faulty investigation. Let us assume in a given
Yes.
case, faulty investigation. On the basis of the investigation, can anyone be deported from the country?
My lord, the faulty
Answer the question.
fault, my lord,
Investigation is
cannot be
bad.
deported.
But is the investigation report a final adjudication process by which an action can be taken against an Indian citizen?
My lord,
Obviously, no. There is an adjudication mechanism by way of a foreigners tribunal where you are given a chance. You have to show us
My
that
lord,
I did not get a
my
chance to the
submission is
tribunal.
that the right from the beginning, the making of case shall be fair. If the reference is faulty, it will develop in a
Mr.
fault
Siddhar,
manner.
Your argument may hold good if the reference is answered totally basing on the investigation report without any application of independent mind to the material before the tribunal. But if the tribunal has examined the material before
My
it, the
My
evidence,
lord,
and have come to an independent finding, which is the duty of a tribunal.
my lord, yes, my lord, in
then
paragraph
how do
98,
you go
in
back
pa-
to the investigation?
my lord,
which
in
does not
paragraph
have any meaning?
98 of the full bench judgment, it has been clearly said, the tribunal should record its satisfaction,
Yes.
whether the materials available before the court tribunal is sufficient to make out a case or not. That should be recorded.
That
That
has
means
been
the
done.
tribunal is to see whether the reference was made correctly or not. If there is a faulty reference, the tribunal can
That may be a
remand
sufficient-
the matter for fresh investigation.
That may be a
That never
sufficient-
done.
That may be a sufficient, we'll consider.
As far as the investigation is concerned, also this case, there was a series of matters which have been already heard by this division bench. And the division bench is part of the. This matter has been already settled, they haven't gone for any kind of appeal or something like that. That
My lord.
that case is already there, Sarifa Begum's case.
My lord.
This is the matter.
Which case?
All people, all the councils have got opportunity to argue them.
Ma-
Argue them.
My lord, there are recent judgment also 2021 3GLT in Sunaka case. This honorable court has said that charge should be specific, not vague. That has been also not rolled out, not specific.
Specific.
We'll consider, we'll have.
My lord.
Specific charges, then you are a foreign. It cannot be elaborated more. If had it been a criminal matter, then it would be like section and all this.
Huh? ফরেনার কথা আমার আপত্তি নাই কিন্তু সিটিজেন বাই আন্ডু ইন্টারপ্রিটেশন মানে ফরেনার্স কার্টও আমার আপত্তি মাইল আমার আজ একটা কিছু কথা মানে টোটাল নাম মানুষজনই কথা নাও ইজ মোর দেন 80 ইয়ার্স এনেকা কিছু কি গ্রাউন্ড কি তুমি বাপেকর নামটো তুমি ক'ত আছে দেখা বাপেকর আইডেন্টিটি প্লেস অফ বার্থ 50 years old এনেকা একটা কেস আছে এগুলা কি হয় there is some there should not be any indulgence to the parents genuine citizen foreigners of আমার আপত্তি নাই আমি একটু বিচারি ফরেনার বাংলাদেশ को जब बांग्लादेश ना बेटर हम जारानी बांग्लादेश ना बेटर बांग्लादेश को ना तो गने कुंभक पठाले এটা রিক্সাওয়ালার ইন্টারভিউ পেয়েছিলাম ইন্ডিয়ার করে বাংলাদেশ রিক্সা মানে তার পিছিয়ে তুমি ইন্ডিয়ার করে রিক্সা চালা রিক্সাওয়ালার ইন্ডিয়ার গুয়াহাটি রিক্সা চালালে মাত্র 3 রাত মিনিমাম 50 Yes. Biplab Lane.
Lordship. Lordship, the impugn order. Your Lordship, my grandfather name appeared in the voter list of 1965. Your Lordship, in the same village, my parents' name appeared, Your Lordship, in the year 1977, along with my grandfather. Now my mother, whose name appeared along with my grandfather in the same village, is still residing in the same village. She appeared before the tribunal and deposed that the petitioner is her daughter, Your Lordship. Your Lordship,
What is your age?
Lordship, Your
Age.
Lordship, my age, Your Lordship. My name appeared in the voter list of 1997 after marriage, Your Lordship.
Your age.
Yes, Your Lordship. Around about 45 years as per the affidavit, Your Lordship.
By when?
Your Lordship, as per the affidavit, Your Lordship, it's
Now?
yes, Your Lordship. And my name appeared along with my husband name in the year
So
1997.
your date of birth should be around what?
My date of birth should be around 1979.
79.
There is a school certificate which suggests that I left the school when I was in class 2 in 87, though it was not proved, Your Lordship. The headmaster is an appear, Your Lordship. Lordship? Sorry. No, Your Lordship, that certificate has not been proved, Your Lordship. So, Your Lordship, see, her name appeared in the voter list of 1977. She appeared before the tribunal. Your Lordship, there were certain certificates, Your Lordship, which have been placed, Your Lordship, but they were not proved, Your Lordship. Yes, Your Lordship. Your Lordship. Your Lordship, may I pray for interim, Your Lordship? Your Lordship, since the evidence of the DW2 has not been rebutted, Your Lordship, and it remains unshaken, and it's as per Your Lordship 2015 1 GLT 941, Your Lordship, and evidence that has not been rebutted, Your Lordship, it remains unshaken, Your Lordship. Your Lordship, Your Lordship, that I have, Your Lordship, stated, Your Lordship. Well, I came to know about the order only in 23, Your Lordship.
May I please, your lordship? My lord, in this case, my lord, the petitioner was declared foreigner within the stream 1166 to 25/3/1971, my lord. Long that, but in the judgment, my lord, the petitioner's name has been wrongly typed, my lord. And the petitioner's fathers has taken the initiative, appeared before the, received notice and appeared before the tribunal and contested the case, my lord, by filing the documents. including a registration certificate of registration, my lord. But the learned tribunal, my lord, held that the petitioner is a foreigner within the stream, my lord. My lord, order was passed long back, my lord, the 21/4/1988, my lord. My lord, the 23, my lord. Almost most. Yes, no? 6. My lord, as per rules, my lord, rule 19, up to as per notification, government notification, that
You have approached this court for correction. Then it will be possible, right? You can give them that.
my lord,
It's correct.
for that, my lord, he could not, petitioners could not register their names. And my lord, in appropriate cases, my lord, if there is a judgment, my lord, in appropriate cases, this honorable court may direct for registration. In appropriate cases, my lord, by exercising the power under Article 226. My lord, one point, my lord, is that, my lord, his father, petitioner's father, has registered himself as a citizen. Only that document, my lord, can we see why it is rejected? That is, due to time barred, my lord, I have not challenged that. But otherwise, also, my lord, that judgment, my lord, prima facie is not as per law, my lord.
Time bird, where do you get time bird?
Time, my lord, the most time has spent, my lord, not time barred.
Or if you are making a submission time bird, it will be equally applicable in this case.
No, time barred regarding challenging of the.
Where is the bar?
I have,
Is there a bar and limitation act?
no, my lord.
Then why are you saying time bird? You know it's barred equally,
Actually, no one.
because we are exercising equitable jurisdiction.
My lord.
It's even the interpretation is more stricter. Limitation, even if it's covered by limitation, you may still hold that you have been not accepting due with due diligence. It latches.
My lord, petitioner's father took the initiative, take a step, but his father, mother,
How do
both
you explain 26 years?
all died, my lord. All died. So petitioner was
years.
not aware of the judgment.
Where is your explanation?
My lord, I have
And what explanation? Will explanation get over your equitable rights?
my lord. My lord, can you see that I have submitted the judgment page?
Where explanation?
Explanation, my lord, page starts from page paragraph 10, my lord.
Yes.
Paragraph 9, my lord, paragraph 9, page 7. The petitioner states that they were not aware of the said judgment passed on 21/4/1988 as a late Sachindra Kumar Das, the father of the petition number 1 and 2, had appeared and contested the case. Then, my lord, paragraph 10, that recently on September 23, 2023, a policeman Hauragat police station getting some information from the office of the SP Karbi Anglong, informed the petition number 1 that during the lifetime of his father, the AFT case was instituted against them and they were declared foreigners, and asked the petition number 1 to inquire and take steps accordingly. Otherwise, they will be in trouble and may also be arrested in connection of the said case. That after learning about the said fact, the petition number 1 searched the old papers and documents of his father and found a copy of the judgment dated 21/4/1988. And immediately he discussed the matter with an advocate, Mr. P.N. Boro of Diffu Court. Mr. Boro, after going through the judgment, advised the petition number 1 that they have to register their names before the registering authority, as they were declared as a foreigner within the stream of 1166 to 25/371, as per the provisions of section 6A3 of the Citizenship Act 1955 as amended up to date. The petitioner then approached the SP Karbi Anglong Ifu on the 21/9/23, who is the registering authority to register their names as per the judgment dated 21/4/1988, constituted so and so. The SP Karbi Anglong Difu, being the registering authority after going through the said judgment dated 21/4/1988, opined that there is delay in approaching him, and moreover, there is a mistake in the judgment in typing the names of the parties. From the judgment dated 21/4/1988, it is seen that the names of parties wrongly recorded as State of Assam versus Kheru Das and 4 others. But my lord, petitioner father's name was Sosindo Kumar Das and others. Instead of Sosindo Kumar Das, my lord, it is typed as Kheru Das. Whereas the case was instituted against Sosindo Kumar Das and 4 others. And the learned foreigners tribunal Difu should have recorded the party's name as Sosindo Kumar Das versus State of Assam versus Sosindo Kumar Das and 4 others. As the names of Sosindo Kumar Das and 4 others were not mentioned as the names of parties, the SP Karbi Anglong Difu refused to register their names until the record is corrected with proper names. Then, my lord, paragraph 19, my lord. My lord, paragraph 14, that thereafter the petitioner, through their engaged lawyer, tried on 4/10/23 to correct the names of the parties in the said judgment dated 21/4/88 before the Foreigners Tribunal Difu Karbi Anglong, but the learned member of the tribunal Difu refused to correct the same, being the judgment passed by earlier member in 1988. The petitioner thereafter applied for a certified copy on 5/10/23. The judgment dated 21/4/1988, which was obtained on 25/10/23, and again approached the SP Karbi Anglong Difu on 26/10/23 to register their names, but he refused to accept the certified copy of the judgment.
You say you have, you're trying to project that in the judgment at page 31.
Well,
The name has been written as Kheru Das
Kheru Das, my
in
lord.
the first part only.
My lord.
But if you read the judgment, there is no reference of any Kheru Das,
Kheru Das.
but there is reference of Sachindra Kumar Das.
Right.
How many times Sachindra Kumar Das has been written in the judgment? Have you noticed?
Many times, my lord.
Not many times, 10 times.
My lord.
10 times the judgment has referred the name specifically.
My lord,
Is there any confusion?
my lord, the SP is,
After 30 years,
my lord, SP is
we were
reluctant.
only, we are going by Kherudas, you did not know it was against Sachin Kumar Das.
But
10
the,
times.
only because of Kherudas, my lord, the SP now refused to correct, register their names. Because otherwise also I have annexed the notice also, notice was issued to Sachin Kumar Das. But only because of this Kherudas, my lord.
Where is your written statement?
Written statement, my lord. I have not annexed, my lord. It is not supplied to me, my lord. And moreover, my lord, reference to the paragraph.
Okay. The notice at page 15,
Notice, my lord. Notice was accepted, yes. Notice page 15, 16, my lord. 15 is the type copy, 16 is the notice, my lord.
what are your names?
Sachindra,
Your name.
yeah, Arjun Kumar, Arjun Das, my lord. Arjun Das, Radhakrishna Das, and Menuti Das. These are the three persons. They were the party. But the notice was served to the father, my lord. Yes, and the head of the family, he has contested the case.
What are you, what relief are you seeking now?
My lord,
What is the relief you are seeking?
my lord,
What is your prayer now? before us?
my lord, my prayer is that a direction may be given to the foreigners tribunal before to correct the name of judgment by putting the name of the petitioner, others, my lord, Sachindra Kumar Das and others. And after correction, my lord, the registering authority may be directed to register them.
Where is the communication from the authorities that now because of the change in name or and the name being different, they are
My
not
lord,
registering. But
my-
before answering that, you have to tell us that what took you more than 30 years to approach the authority to register your name, and in this time you had been exercising your right to franchise.
This, my lord, the petitioner was not aware of the judgment. That's, my lord, and the petitioner father also died.
The notice was in respect of all of you. Come to the
Actually,
come to the
notice was served upon the father, Sachindra
come
Kumar
to the
Das.
notice. It
And
was
he-
contested. It was not a case that it was not an ex parte proceeding.
The petitioner father, my lord, contested the case
When did he
as a head of the family,
When
my
did
lord.
Sachindranath Das pass away? When did he expire?
Yeah, I have annexed the, my lord, death certificate also.
When was it?
He was died on, my lord, 2003. Exact date. 8/7/2003, my lord. Sachindra Kumar died,
And the judgment was of
Eight.
1988.
my lord.
Opinion was of 1988. 88 to 2003, you did nothing to get yourself registered. Even giving bona fide, all bona fide,
My lord.
you are not aware. No step taken from 88 to 2003.
And my lord, with these are poor people, my lord, they're actually in the judgment, it is also not directed that you are to register their name. So they are not come, they are innocent, my lord, they do not know at all.
What's given, what is the
What?
expression in the judgment? Can you read the last part? In the opinion,
My lord,
will the judgment advise you what to do? Please read the last
in the result, I hold that the opposite party, Shosindra Kumar Das and others are foreigners under section 2A of the Foreigners Act 1946. Read with section 3 to 6A of the Citizenship Act 1955, having the infiltration in between 1166 to 24/3/1971.
Thereafter, tribunal will advise you what to do.
My lord, the people are, they are innocent people, my lord, they do not know about the position of the law, my lord.
There is one more technical difficulty.
The period.
And my lord,
Because he has been, originally he has been continuously deciding to get himself registered.
yes,
So he has to prove that he has been residing continuously in a site. Ordinarily, he is a resident of the state. That has to be also. That's the stay provision of the.
he is still in the same place, my lord, residing. He is still in the same place.
This statement is not, good. He has to prove it. So that's, it's a mandate of the state.
Where it was stated that you had approached the authorities for registration? Where is your application?
My lord, petitioner accompanied with one advocate, Mr. P.N. Boro, my lord. I have
Where have you stated?
that, my lord. At paragraph 11, my lord.
Please read.
After learning about the said fact, the petition number 1 searched the old papers and documents of his father and found a copy of the said judgment dated 21/4/1988. And immediately he discussed the matter with an advocate, Mr. P.N. Boro of Difu Court. Mr. Boro, after going through the judgment, advised the petitioner that they have to register their names before the registering authority, as they were declared as foreigners within the stream of so and so members. Then, my lord, petitioner approach. The petitioners approached SP Karbi Anglong, Difu, on 21/9/23, who is the registering authority to register their names as per the judgment dated. The SP thereafter, my lord, these things. The SP thereafter, my lord, paragraph 13.
Yes, please read.
SP Karbi Anglong Difu, being the registering authority, after going through the said judgment dated 21/4/1988, opined that there is delay in approaching him, and moreover, there is a mistake in the judgment in typing the names of the parties. From the judgment dated 21/4/1988, it is seen that the names of parties wrongly recorded as follows: State of Assam versus Sri Kheru Das and 4 others, whereas the case was instituted against Shosindra Kumar Das and 4 others. And the learned foreigners tribunal Difu should have recorded the names as State of Assam versus Shosindra Kumar Das and 4 others. As the names of Shosindra Kumar Das and 4 others were not mentioned as the names of parties, the SP Karbi Anglong Difu refused to register their names until the record is corrected with proper names. Thereafter the petitioner, through their engaged lawyer, tried on 4/10/23 to correct the names of the parties in the said judgment dated 21/4/88 before the FT Difu Karbi Anglong, but the learned member, Foreigners Tribunal Difu, refused to correct the same, being the judgment passed by the earlier member in 1988. Again, my lord, the petitioner approached thereafter applied for a certified copy on 5/10/23, the judgment dated 21/4/88, which was obtained on 25/10/23, and again approached the SP Karbi Anglong Difu on 26/10/23 to register their names. but he refused to accept the said certified copy of the judgment as the names of the parties had not been corrected by deleting the name of one Kerodas and others.
Page 20 is the voter list.
Page 20. Page 20 is the voter list, my lord.
Which year?
This is 97.
The opinion was of which year?
Opinion 88. I have annexed, my lord, that he is continuing here, my lord. That's why I'm in the writ petition I have annexed.
And you were, Arjun was, what was the age of Arjun?
At present, my lord,
No. In 97, when he had voted,
or June, my lord, 30 years,
30 years.
my lord.
That means on the earlier years also he had voted in spite of an opinion. You took advantage of your negligence by neglecting to register yourself. You took advantage. Now you say that now since there is some detection, you want yourself to be registered.
My lord, I have stated that the notice, notice received by the father, my lord. And
And his father also voted in
Arjun
97.
was actually
Leave aside Arjun. In 97, father was also there.
there, my lord,
He had voted in spite of the opinion of 1988.
my lord.
So, you knew there's a judgment, interpreted judgment. In violation of that, you kept on voting. What is the equitable right now?
My lord, one thing I have to point out, my lord, here, that under the rules, my lord, rules 19 of the citizenship rules, rule 19, sub rule 2A, my lord, by the notification dated, my lord, 16th July 2013, my lord, those who are not registered their names before 2013, my lord, all the persons are, my lord, allowed to register their names within 30 days from the date of notification. But, which may, if anybody failed, my lord, then they extend to up to, my lord, 180 days further. So, my lord, if I interpret,
Which rule are you?
my lord, rule 19 of the citizenship rules 2009, rule 2A, capital A. So, my lord, up to 2013, actually, my lord, that,
Just a minute, first September notification.
my lord,
Which notification?
notification, my lord, that is, rule 2 capital A, my
No,
lord.
notification dated
Notification
first
dated
January
16 July 2013.
17, what? Notification dated?
It is stated in paragraph 2A,
Notification dated.
dated 16 July 2013, with effect from 16/7/2013. In the bottom, my lord, two explanation inserted sub rule 2,
No, you are
Rule
referring,
19.
you are referring to which order, which act?
citizenship rules, the citizenship rules 2009.
Just a minute. Citizenship
This
Rule
is only
2009.
regarding non-receipt of the order as well the two
No.
conditions have been given.
No.
One is non-receipt of the order of foreigners tribunal, and secondly, refusal by the registering authority. Can only you get this access.
Of the rules, which rule are you referring to?
No,
Two?
road safety
That
and
ro-
citizenship rules 2000.
No, which one?
Two capital A,
Two A.
sub rule two A.
Two conditions they have.
Rules গুলি কইছে। এখানে যেটা Rule 2009, 2A.
Two capital A, my lord.
There is a right. Where have you got, which book are you referring?
My lord, I am referring.
The old book.
All still. Wait. আসেনি কি আমার এখানে? হুম। বলুন।
Which page of your book?
My lord, page number 205.
Right. Nineteen to A.
92.
What are you
19,
saying?
19 to 19, yes,
Never said 19. You are saying 2A, 2A, 2A.
sub rule 2A, my lord.
You have to say 19 to A.
Yes, yes.
Unnecessary. Nineteen to A, please read.
My lord. A person who has been declared as a foreigner by the Foreigners Tribunal prior to 16th July 2013 and has not been registered under subsection 3 of section 6A for the reason of non-receipt of the order of the Foreigners Tribunal or refusal by the registering authority to register such persons as a foreigner on account of delay may within a period of 30 days from the date of receipt of the order passed by the Foreigners Tribunal or from the date of publication of this notification, make an application for registration in Form 18 to the registering authority of the district in which such person is ordinarily a resident, provided that the registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 180 days.
You tell us why this is not applicable. You have read this.
Right.
There are at least 3 reasons why this is not applicable.
My lord, I beg to submit that, my lord, since delay of since 88, my lord, it may be excused here, my lord, by extending the time, given an opportunity of those person who has
See,
been
2A
declared as a foreigner, my lord,
is a special provision which was
within the stream.
inserted later on in the year 2013.
My-
There are certain preconditions attached to 2A. It's a special provision. Let us read again. a person who has been declared as a foreigner by a foreigners tribunal. This part you meet, you have been declared a foreigner as a foreigners tribunal prior to 16 July 2013.
My
Okay,
lord.
everything okay. And has not been registered under 3(6)(a)
My lord.
for the reason of non-receipt of the order of foreigners tribunal or refusal. You do not meet the first two requirements. Neither you come out within the ambit of non-receipt of the foreigners tribunal's order or a refusal by the registering authority.
Well.
The first precondition you do not meet. Second, you come, then if you meet those conditions, let us assume that you meet these conditions, then you get a time of 30 days. From which date? From that date or the date of publication of this notification. And there is also a further extension, provided the registering authority may reasons for writing, extend the period for period not exceed 180 days.
Well,
You do not come within any of the extended provision also.
my lord, that is there, my lord. That's why, my lord, I
How
have,
do you-
I have,
How do you take the benefit of 2(a)?
my lord,
If you want to
I-
take benefit of 2(a),
my
which is
lord,
extended provision, you have to make out a case of 2(a).
my submission is that, my lord, in by this notification, my lord, 2013, my lord, extended the period. I want to submit, my lord, that the 1988 order was
Have we
passed.
prevented
But-
you from submitting?
No, my lord. I
Please
have
submit.
explained that I was not aware of the judgment, and after the death of my parents, my lord, I have got information from the police that a case was registered against my father, and we are declared foreigner. Thereafter, my lord, petitioner has searched the old papers and found one
Even
judgment.
then you have not come in
My lord.
within 180 days or 30 days.
And
What is the limitation here?
my lord, that limitation, my lord, in appropriate case may be, my lord,
Within a
extended by.
period of 30 days from the date of the receipt of the order passed by the foreigners tribunal or from the date of publication of this notification.
My lord, what is my submission, my lord? That this honorable court also said in I have in the judgment, my lord, in appropriate cases, my lord, in appropriate cases, it may be extended, my lord.
Page 20, come to page 20.
Page 21.
Voter list of which year?
Voter list of 1997, my lord.
Okay, names of all of you are there. Father's names are also there. Your father passed away in 2003, correct?
My lord,
Your father's name was there.
yes,
When did you apply for the certified copy?
applied on the 31/5/2008, my lord.
2008.
My lord. 2000 is the voter list.
Why did you apply for 2000 in the year 2008 of a voter list of 1997? You have not applied now because you have come to know.
No, my lord, these are the names of.
Why did you apply for a certified copy in the year 2008? What is the relevance? These are contemporaneous events.
My
We
lord,
have to take into
my lord,
consideration.
this may be perhaps, my lord, due to NRC and extraction, my lord. Maybe, my lord.
NRC when?
Maybe, my lord. I am not sure, but maybe, my lord.
Go to the next
Voter
page.
list.
Go to the next page. Next, voter list. Applied when? Certified copy at page 24.
Next,
Page 24, next voter list,
page 24, 19/3/2018,
19/3/2018.
my lord, he is
This
applied.
was also
This is Radha Krishna Das, the one of the petitioner, my lord.
again 6 years back. Radhakrishnan is also
My
one of
lord,
your
I want to prove that he is constantly residing there, my lord. By annexing those voter list, my lord, my intention is that they are residing in the same place.
Mr. Day, while,
Since-
while you are trying to project your intention, something else has also come up. You apply for a voter list in the year 2008. Why? If your intention is bona fide to project a case that you are continuously residing, you could have applied for the voter list now before coming to this court. You in 2008, you were in possession of a voter list.
My lord, it may be happened due to NRC, my lord, because
2008, there was
NRC
no
provision,
NRC
the
concept.
certified copy is necessary, voter list
2008 was there any
necessary.
NRC concept?
Necessary, voter list is necessary in the NRC purpose also, my lord.
2008.
But
You
my
do
lord,
not meet the requirement of 19(2)(a), any of the requirement, even the extended portion.
my lord,
You
the-
don't have any explanation. You voted till 1997. Even your father voted till 1997 in spite of there being an opinion of 1988.
You want to fight with it. The electric voter list
Not only the present petitioner, his father also, Sachindranath Das. You can come to the first page. 97 voter list.
page 20.
Fathers and rest family members till when they were voting.
my lord, it from which period is got when declared to be foreigner. Yeah, that is 2008. If the very well. Okay. But
Which year?
Yeah. My lord, may you please grant some body actually.
Just the press of two buttons. Their name.
So,
Mr. Huda, which item you are waiting for?
That's right, 27.
We don't like a senior person to wait for long. If you want, we can upgrade your matter.
I'd be happy with it.
Healthcare item. The records have come, we can take for final disposal. you can come at your ease at 2 o'clock. Is it okay? Mr. Kulda, records have come with for disposal. No need of him waiting in here. Normally,
42,
open wicket.
42, three, 43,
42 को है, आइए इसको है। Forty two, 43. Mr. Ahmed, you are for which matter?
My lord, 41, my lord. 41, my lord. There is a Sure.
What's the prayer here?
My lord, some time may be granted to appear before that. My lord, to appear, my lord, as per court order, my lord. Court earlier, my lord, 27, 2023, my lord. Court directed the petitioner to appear before the tribunal on or before 16/8/2023. Here, PS 11, my lord. Kindly see para 6. A voter list of 1977. This is not a part of my record, my lord. Ultimately, my lord, as per instruction of the Election Commission, my lord, page 15, my lord. Page 15, second para, my lord. 77 voter list is not available, but 1979 voter list is available as per instruction from the Election Commission, my lord. Page 15, para, second para, my lord. মানে 77 to 9, 79 to 8. আমি কিন্তু 35 to apply করব, apply করা একটু ভালো। একটু পাতে দেরি হবে, না তুমি স্যার করবে।
That is 308. You can put it.
You paid it what do you mean?
এই প্যাড করে দিতে আমরা 60 নেই। এইটুকু আছে 30 টাকা।
We fix for it.
হ্যাঁ, হ্যাঁ। কিন্তু আমি 35 পেতে আমি তো লিখতে পারলাম না। 5 নট পারলাম। যখন
Pay করবে না কোনো করলে করতে হবে।
আমি খুশি কিন্তু কাজে আপনি 35 করে দিলে আপনার আমি ভালো।
Obligation তো করতে হবে। হিসাবে 230 তারিখ।
ওখানে তো কিন্তু না।
তুমি আপনার থাকবে না।
What are your reasons for not appearing in time?
Yes, my lord. Applied for voter list for 1979, my lord, page 18, my lord. 1/9/2023 applied, my lord. Subsequently 5/9/23, my lord. Already a date is over, my lord.
See, that is not the precondition. The correction order of 14/8/2023 at page
Yes,
15. You applied for a correction
Yes,
by filing an IA upon
Yes.
disposal of writ petition,
yes.
which was disposed of on 27/2023.
Yes,
Writ petition was disposed of in
Yes.
July.
yes,
Then you filed this IA, which was considered on 14/8.
yes,
You had said that in paragraph 6 of the order, the voter list of 1979 should be read
77,
instead of 77.
yes,
Okay, now that IA has been allowed
yes,
by directing you to appear on an extended date of 38
yes,
2023.
yes.
This writ petition, this certified copy you have obtained on 21/8/2023.
Yes.
You come to page 13,
Yes,
1/3. When did you receive the certified copy? 21/8/2023. And the date of your appearance was fixed on 30/8/2023.
Yes.
Thereafter, you cannot take the plea that you had applied for a voter's list. It ought to be in your hand.
No, my lord. This voter list is not on my record, my lord. That
Then
voter
where
list
did you
subject
say?
only, my lord, as
Where
per
did you
court
say
order,
before
my
the
lord.
court? That is a, oh, you only said that there was an incorrection, there was an error in the order 79 instead of 1977.
Yes.
Did you say that I need time to apply for a voter list?
my lord.
Give me time.
At the time of hearing, my lord, AI Ali, my lord, election commission, my lord, he has submitted that 77 voter list is not available. There is a 79 voter list is available. Accordingly, court pass order. A petitioner approached the tribunal, my lord, but tribunal said that you may come with voter list of 1979. Accordingly, petitioner applied for certified copy 1/9/2023, which is obtained 5/9/23. Already date is over, my lord.
And from 5/9 to now, when did you file this IA?
IA is filed on, my lord. I have filed on 10/10. A petitioner ready to appear, my lord.
The Kolita, what is
Okay, I mean, whether they have approached a tribunal or time, or there is no evidence to be brought in the record. If by his statement, it cannot be limited.
but nonetheless, there was a judgment of remand by this court, which was, which has attained finally. You did not file any appeal against it.
ঘুমাইছিলে কি করবো টেনশন আছে না ওদের সবার হয়ে গেছে ওইটা ঘুমাইতে সেটা লাগবে না তাই দেখে না তাই তো ইন্টারেস্ট পেয়েছি আমি কন্ট্যাক্ট করে দেওয়া যেত টাইম লেগে কন্ট্যাক্ট করছি আগে হচ্ছে কি মানে করতে করতে পার হবে না
But
লাভ আছে এটি তো একটু রিপোর্ট কপি করবে, একটু রিপোর্ট কপি করবে, রিপোর্ট রিপোর্ট। অর্ডার আছে
Right.
My lord, I may be allowed to see the record of item number 16, my lord. My lord, in presence of. My lord. Yes, Lordship.
There are some IAs, will first dispose of those IAs. I come. I hear you. Oh. Item number 14.
42.
May I please your lordship? It is an individual application in WPC number 4946 of the total paying for amendment of the writ petition under order 6 rule 17 related with section 151 of the Code of Civil Procedure as per order dated 38/2020 passed by the honorable court in WPC number 4946. My lord, there is some my lord. My lord, the appeal is stated after filing listing of the writ petition by WBC number 456 before the zonal court, it is suddenly came to the notice of the advocate of the applicant that in paragraph number 4, page number 11 of the writ petition, it has been wrongly stated as NRC of 1966 total details of the grandfather of the petitioner, instead of NRC voter details of 1966 of the father-in-law of the petitioner. It be father-in-law, my lord. The said mistake is also in the last cost title in page 2 of the writ petition and CL number 5 of the index of the writ petition. That the applicant best stated that in the translated copy of Annexure 2, page number 31 of the writ petition, the name of the father of the grandfather, that is great grandfather of the petitioner, is wrongly typed as Gonishek instead of tag name of Sopisek. It will be Sopisek. The said mistake also reflected in serial number 1 of the family tree column of the writ petition. That the applicant best stated that another mistake is noticed in the translated copy of the Annexure 5, page number 38, wherein the name of the mother-in-law of the petitioner is wrongly typed as Mukisa Bibi, wife of Kapatshek, instead of tag name of Surija Bibi.
Yes, Miss, what do you? There are some typographical errors. And there is no amendment with regard to the prayer.
Very much.
So only with regard to facts in the repetition.
Lordship, you may withdraw and file a fresh one, Lordship.
That would have been the ideal course of action. Or otherwise, that would have been
Since
better.
LCR has also not come till now.
Nothing, no order has been passed in the repetition.
Yes. You can go and
The
file
task
a
can do
fresh
that, it
one.
will be better. You withdraw, file a fresh
Too
repetition.
many errors, Lordship.
I think it will be better. You gradually go to you are trying.
Petition with it, yes.
Not Mr. Adas for the applicant. The applicant, the petitioner. Will be connected to application number 4946. The order. 17/03/2020 passed by transport and for by filing this application, applicants pray for filing an amended petition and there's certain typographical error. Which I- After certain deliberation of the I petition I.
No, 25.
May please, Lordship. Lordship, I have been filed, my lord, earlier occasion, my lord, matter was disposed of. So, direction was given to appear before the tribunal father of the proceeding is DW2, my lord. After obtaining the certified copy, my lord, we sent to the copy of this order, my lord, then after knowing the father was died, my lord. DW2, my lord.
How we can grant you this prayer?
My lord.
Earlier, it was the direction of the court
Yes, sir.
or re-examination of the DW.
Re-examination of the DW2.
That he is no longer alive as expired. Now
That's right,
question of granting you further prayer doesn't allow. How we can modify that order? Can anyone can got in the shoes of DW2 now?
My lord, DW2 already, he was examined earlier, my lord. Second time, my lord, direction was given, my lord, second time.
True. Is have expired that you cannot examine DW2 now.
My lord, against whether there is a brother of the petitioner, my lord, he also deposed in this earlier petition, my lord, DW3, my lord. Now, my lord, direction was given to examine the DW3, my lord, instead of DW2.
Lordship, that was not the prayer earlier.
Paragraph 5 of the earlier order.
Yes, my lord. In view of the above, we remand the matter back to the tribunal for appreciation of the evidence of DW2. The tribunal may record the real appearance of DW2 before this tribunal for further cross examination by the state through the Home Department. The tribunal shall also verify and satisfy itself whether the person appearing before the tribunal as DW2 is the actual Hassan Khan, son of Halim, of the voter list of 1960 of the village Tukmonach. After doing the needful, the tribunal shall pass a revision order thereon, my lord. My lord, this DW2 already expired, my lord. That is why, my lord.
Second part is okay. The first part for evidence.
Already record, my lord.
Already
Record, my lord.
The second part is that whether this part is left to the tribunal. You care some fact. So because the tribunal the judge is present. Now he has passed. Let me take
Any other case?
modify the order by allowed to reduce evidence to appear.
Yes, my lord.
You had all the options to reduce the best. Either you withdraw or reject, up to you. You have read it now, paragraph 5 of the judgment order.
Yes, my lord.
It's up to you now.
My lord,
Either we,
Replaced by another
another DW, my lord, DW3 is my brother, my lord. He earlier, my lord, he appeared before the tribunal.
Now, try to understand. That will amount to review of the order. Because if you read that para 5 along with para 4, you'll know the coordinate bench of this court have found that if the appreciation of evidence of DW2, perhaps the proceeding may be considered as an impeachment.
Yes, my lord.
That is why the matter was remanded back.
Remand back, my lord.
Thereafter, it was up to the discretion of the tribunal to decide whether the evidence of DW2 for recross examination is required. Now DW2 is not there. It
Not
was a
there, he
finding of the
spared.
court, right?
Expired, my lord.
Only with regard to DW2.
DW2, my lord.
And if we want to alter DW2 to DW3, it will amount to review of that particular order. How can you do that at this stage?
My lord, then, my lord,
Either you dismiss or you withdraw, up to you.
my lord, then you give me 15 days time, maybe given, my lord, to appear before the tribunal, my lord. The tribunal, whatever may be passed, my lord. 15 days time is
It is
given.
not stated when DW2 passed away, and he was supposed to appear in the month of August last year, Lordship. July, Lordship.
As soon as we have filed.
Maybe that is the ground, and now he's
was-
coming for, he would not have appeared.
Earlier, it was listed, my lord, but not reached, my lord. You could take your time, my lord.
When did you file this?
Lord, we have filed, my lord,
December.
December, my lord.
So why you should have filed it immediately after that date or during that period?
July or August order, Lordship.
Into December.
24/7, 2023, my lord, matter was disposed of, my lord. After half 1.5 months, my lord.
And Lordship, no mention, December, Lordship.
Wow.
And no mention when the father passed
Expired.
away.
my
That
lord,
is suppressed
actually,
before this court.
Communication gap, my lord. It is a
They
problem, my
would,
lord.
actually, he should be filing just to pay time. He's taking a recourse to the other way, Lordship.
Lord, give me 15 days time may be given. We
This
appear,
is
my
the
lord.
conduct,
and
Lordship.
submit
Once they have
document,
the
my lord.
order, they don't go and appear, and then they come up with excuses which is not tenable.
What is the present status? Tribunal must have passed
It must have gone ahead, Lordship. They never appeared, Lordship. This is,
My lord, nothing was done, my lord.
Lordship, the
Mm,
saddest
because,
part
my
is
lord,
once a order is
elsewhere-
passed, they don't appear before the tribunal on time. And if
Elsewhere-
the tribunal proceeds to pass an order,
elsewhere-
again they are before this court.
LCR, my lord, is there, my lord. behind
Do
it,
one
my
thing.
lord.
Yes, Lordship.
You have the mobile,
Yes, I have.
just scan it, page number 9 of the I, when it was certified copy was applied.
Even tell Lordship, he is, when he applied for the certified copy,
It's not that you can't even
Maybe,
scan it.
Online copy, my lord. yes.
he's an online copy, didn't apply for a
Original
certificate.
copy, my lord, already scanned, my lord. To the petition on it. Through register post.
It must have attained its finality now, Lordship.
It's not. That's the reason order to be passed, nothing to worry.
He was given another chance by this court, which he missed, Lordship, and now he's filed this IF for extension of time.
Not means because of that, my DW2 was expired. That is why, my lord.
No, when did he expire? It's not before this court. You have not put the date. When did he expire? There's no certificate, no mention, no statement, nothing.
Mentioned, I have mentioned it.
Have you put the date? Please
What
check
date?
it.
Only mentioned.
Only 90 years you have said, no
But
date,
that's
nothing.
Expired, my lord. That is not mentioned, but this is not a reason, my lord. But he expired, my lord. That's true.
Expired when?
Exactly, Lordship. He said that's not the reason he's saying.
Sir, expired when? This is a very pertinent question. When did it expire?
That will reveal, Lordship.
Just a communication with our telephone, expired.
Filed by an approved by an affidavit for communication.
Then-
How did we file the affidavit?
Then my lord will file a
With the
yeah.
telephone.
Hello?
That to healthcare, healthcare.
Up to you to withdraw or dismiss it.
My lord, only 15 days time may be given, my lord, we appear, my lord.
That
Then
we
after
cannot give.
tribunal may be passed the reason order, my lord.
No, no. that will
Whatsoever
not
may be passed tribunal.
There is no requirement of your appearing. Cabinet was given here the opportunity to reappreciate the evidence of DWP, and if so requires, he can be this for first murder first. He is not there, he is nothing. To reappreciate it.
Ms. Verma,
Yes, Lordship,
inform the tribunal about this order very specifically,
and I'll
because there is an observation. At page 11, there are 6.
The recorder here.
no, not this one, Lordship. This
Report was
matter is disposed of, Lordship. This IAS filed in a disposed of matter. Matter was remanded back, giving him time, giving him another chance to appear before the tribunal. And he has not appeared, and Lordship, he failed to appear on the date, Lordship.
Paragraph 7.
Yes, Lordship. The petitioners shall appear before the concerned foreigners tribunal on 17/8/2023. Till the reasoned order is passed, no coercive action to be taken against the petitioner.
The second part is subject to the first.
First part,
Part application upon him
to appear
on 17/8/2023.
and the,
And if he appears, due to pass the written order, will take it forward.
yes,
He
Lordship.
doesn't appear. So there is no restriction of the part.
To go,
A further order
Reason.
up to the remand. Now, has any order been passed?
I will have to take instructions, Lordship. We'll fix it up tomorrow. I'll call up and check up.
We can discuss this, and if order is passed,
Nothing to, it's come to a logical conclusion then, Lordship.
we discuss the- The applicant is had filed the connect with the deputy. It by LLC. An official date 29/9 of the right to interest. Was by order thereby the matter was demanded for of the deputy which some further observation for the comma the relevant part of order dated of the affected order the order also made observation. The Hakka that of them that the DWP because the father has expired and therefore the order may be order is 24/7 is required modified with the further prayer of allowing other competencies to be examined by scribe. Ms. Verma, However, that the date of expiry of the author of projected author has not yet. Further, we point out that though by the organization, the date for application has been filed long thereafter on 18/12/2023. The further that the second part of the prayer amount are review of the earlier order, which is not the condition and purpose of the present. The relevant content have been considered. The order is 756, which has been qualified by the while remanding the matter has been clear that the petition was appeared on the tribunal on 78. The second part of the order that if the result order is passed on no court will is obviously subject to fulfillment of the first part of the order required appearance of the petition on 78. We have also noticed that the primary purpose of remand was for substituting of the evidence of the two, and the petition was given to the tribe to require to seek reappearance of DW for further construction. This the evidence of DW is already on spot, the state evidence can be obtained by the tribe in terms of order dated 24/7. We are also of the opinion that this the petitioner has failed to appear the date that the second part of the order whereby disclaimer regarding court did not be offered. We have also noticed that through a statement has made in paragraph 3 of the application regarding the expiry of the father project application. No date of such that has been given. If you have the above, we find that there is in the according to the thing with the party makes clear that there is no restriction upon Learned Tribunal to pass express orders is not over to pass. In further demand made by the order is put in the connect.
Augustine.
Please, Lordship. Lordship, in I Lordship, correct the order dated Lordship 4/12/23, District Baksha instead of Barpeta Lordship. It should be Baksha Lordship. What your mistake? What about the name petition?
No.
What was there? But you have changed the name petition. No, no.
For in fact, this is from point of place forfeited. Main petition is pending because there is an interim order. We just modify to that extent. While issuing notice, we connect with the petition number 1386 of the by petitioner 104/2023. In the entry, directed the petitioner to appear before this point of place. For RBI as such declared to RBI. The report of the by opinion the regular rate outside like type of order for the six. In application of that on by communication dated 2012-2023 this kind of forfeited. Inform the registry of this store that since the address of the state petitioner of application of is of village Unmota UNMAJA Pothar on the Gopotana police station under Porpeta Road, police station Porpeta Road, which is now under district Baksa. The record of FP case number 342 of 2018 met on Medivin and Superintendent Police Court of Baksa. And as such, the petitioner is required to appear before the Superintendent Police Court of Baksa instead of Superintendent Police Court. The said petitioner of WP has accordingly filed the application for modification of the order that put to the extent that it could now be allowed to appear before the Baksa in terms of the order taken. Could extend the time in terms of custody, therefore, and the communication individual modify the order that is proposed below 12 department, which is a connected that the petitioner has appeared honor order of the honor 20. this. This order. Great. Okay. Pass it up.
Okay. May I please, your lordship? Lordship, I'm not in this case as the learned counsel emphasized on legs in court number 23. I have been instructed short date may be given.
Yes, Mr. Nath. Any information has come? It was communicated only on 13th of February. Office not declared. So today we are only 16th. We fix it on 6th of March. From the office note dated 13 to 2024. We have seen that the order dated 30/01/2024 has been communicated to Chief Judicial Magistrate Kamrup Metro. They say that I 13 in view of the place this matter on 6th of March 2024, enabling Chief Judicial Magistrate Kamrup Metro to apprise the court about the status of FR number 443 of dated 31 pertaining to Pandora case number 394 as mentioned earlier on 30/01.
Right. Nothing. It was not.
Let us hear her. Both the petitioners. Yes, ma'am.
Lordship, in this case, Lordship, Lordship,
Is there any scope for security? Unless you factor it to the fact. You can challenge this by period.
no, we are not on that. This order is not in time, Lordship. There is illegality regarding this.
That order has been put. There is no urgency.
But Lordship, PTNDPS, the motto of the PTNDPS is
Want a hearing, we not hearing today,
Lordship.
because it's not urgent. Period is expired. It has been put. The people think that the order may have some stigma for it.
Yes.
Further justified by some other orders, where you
Yes.
can secure it.
Yes,
And
of course.
for examination,
Yes, of course, Lord.
This matter has been listed only because we wanted to know why the petitioners are in custody.
Yes, Lordship, all last.
Even after the
we also
That-
were not the right of exercise of
Yes,
Then you will immediately
yes,
ask to release.
yes.
That was the purpose. Now, other cases have been brought forward.
Yeah.
With theatre or-
On last occasion, Lordship, I apprised that thing, Lordship. They were arrested in connection with 180 by 2022. In that case, they have imposed this order, Lordship. So in that is the commercial quantity. That is why bail was not granted in that. The petitioner also not approached for that also. But there is a stigma to that. That is why, Lordship.
That will examine the.
Lordship.
If you want.
Whether PIC that applicable for
Yes.
whether grounds are proper
Yes,
delay in how to respect.
yes. Fix any date, Lordship, for a hearing.
Pursuant to the order dated 12/02/2024. Ms. A. Kayan, Lanet CCC. For the response number 1, 1 and 2. 1, 2, 1, 2, 3. As well as Mr. T. Nath, Senior Government Advocate Assam. For the respondent numbers 7 to 10. What is the response? Apprise the court that though the detention period of the petitioners under PIT and DPS have expired on 18/01/2024, but both the petitioners have been detained in jail as under trial prisoners in connection with NCB C oblique number 03/2022 under section 8 in bracket C, read with section 21 within bracket C and 29 NDPS Act. The respondents have already filed their affidavit in the matter. In Botimet, issue rule. Notice in these cases were issued earlier. Issue rule, since the respondents have already filed their respective affidavits.
When is the matter, Lordship?
It will come for hearing in its usual courts.
Problem.
Both is a common order. Both are now in custody in different case or same case.
Same case.
They are in custody in the same case. Common order.
Both are tagged.
Yes, yes, both are.
Lord.
Yes, Mr. Huda.
Lordship, having been obliged, highly obliged, Lordship, I give your Lordship indulgence.
Yes, Mr. Huda.
Lordship, I gave your Lordship indulgence to place one matter at the outset, Lordship. This has been two FTC cases filed before the Honorable High Court by actually WPC case number 2150/2017 and another one WPC 26
Just a minute. 2150.
2150/2017
Hmm.
and another 2636/17. So fortunately, and in the advertence actually, this matter was related to, this case was filed by another advocate and one
Just a
case
minute.
was filed from
Relates
our
to same petitioner.
Lordship.
Relate to same petitioner. Both the matters relate to same
Related
petitioner.
to same matter, it should have come analogous at that time. But if you are ignorance, inadvertence, that could not actually draw the attention of. I am just giving this.
Please take your seat for a while. Just a minute.
Thank you. Manoj, is it?
Two six three six of 2017.
Got
The other cases.
Two, 6, 3, 4, 17. Another is 2150, 2017.
Okay.
Two 6, 3, 6, 2, 6, 2, 6, 2, 8 are present. This is the 2, 6, 3, 4. 2, 6, 3, 6. 2, 1, 5 is already decided. Another case you mentioned 2, 3, 6, something like that. Only two cases. This one?
Addition. 2150, right? There is no case, 2656, there is no. Case. Two speaker, huh? Please take your seat. Okay.
89 voter list. Yes.
Your name has accepted. Up to the
31. Yes,
Your name had come for the first time.
Lordship.
Kindly see the age. Age of the
Yes,
petition.
26.
26.
Yes, sir.
Can you come to the voters list of 1985 at page 41?
Okay, 41. Yes, 41. Page 40.
41.
41 is 41.
1985 voter list.
So-
85, where is his name?
23.
Where is his age? Where is his name?
Right. Punto? What is it? Oh, that is not there. huh?
He was eligible to vote. He was 21 in 1985.
Yes. But in this voter list, is not appearing.
What is the link document you are relying upon?
Lordship, yes.
Which is the link document you are relying upon?
Jamabundi, which is actually on record, 31, 33,
Please let us have a
33 page,
page 33.
and also. Yes, 33, both the names are there, Abdul Sattar, A. Kalam, Sarafuddin, all are sons of Jabbar. And this, as per the order that is also, names of high serial number so and so are mutated in place of Pata, Dar number 3 as legal heirs. This is actually 33, it is there. And also subsequently.
33.
Yes. 33 annex third G. And subsequently, politics that names have appeared. And here. That's really page 30. Page 43, there his name again appearing there. 43, 77, Sarafuddin, Jabbar. 47 also, Sarafuddin, Jabbar, and XRL. Here.
তার উপর মোহাম্মদ আব্দুল সত্তার, পিতা আব্দুল জব্বার, চোদ্দ নম্বর আব্দুল কালাম, পিতা আব্দুল সত্তার, 15 নম্বর তারাপতি, পিতা আব্দুল জব্বার, 16 নম্বর মোহাম্মদ অম্বিয়া খাতুন, পিতা আব্দুল জব্বার। কোন মতে হবে এটা perfect set কর। In the written statement, you did not state anything of your siblings, brothers and sisters. How many you have? Who are they? In the written statement before the tribunal, there was no mention about your siblings. Not to talk about names, their details, nothing. Now, this question, why we are putting, is that you have placed before us the order passed in Abul Kalam's case.
Yes.
And projecting that he is your brother.
Right.
His father's name is also Abdul Jabbar, no problem with that.
Yes.
But he has to be your brother.
Yes.
You have not stated anything that he is your brother, or you had a brother called Abul Kalam.
But son of Jabbar.
Mr. Putra,
That's it.
ask your colleague to read page 24.
Page 24. Right.
WS. WS.
WS.
You take your seat. Ask him to read.
Oh.
Take your seat. Take your seat there.
Okay.
My lord, the written statement submitted by the opposite party Sharafuddin of this instant case are most respectfully swear as under that the report submitted by the SP border Morigao district that I entered in India illegally without any valid passport is
You come to
strongly.
paragraph 4. You can skip paragraph 1, 2, and 3, come to 4.
Yes, my lord.
I have seen.
Okay.
Let me,
Okay,
I
Mr.
have,
Hooda, you
I,
want to read? Okay.
I am,
Mr.
I am,
Hooda,
I
yes,
have to
yes,
read.
please read. Okay.
Please,
take it. Mr. Hooda will read.
Lordship. Paragraph Lordship.
Four on what?
That the answering OP begs to submit that I was born and brought up at village Durabundi, now under PS Moirabari, in the district Morigao, present Assam in India, and as such I am a citizen of India by birth. Annex A, photostat copy of Gaon Bura certificate enclosed herewith. That my father, namely Abdul Jabbar, is enrolled as a legal voter in the voters list of 1965 under 84 number Lahorigat ACLS bearing number serial number so and so at the village Durabondigao under Moja Moirabari in the district of so and so. This is Nogao. Annexure B, photocopy of the visa voter list of 1965 showing my father's name enclosed herewith. That my father name is enlisted in the voter list of 1970. 5 serial number so and so under Moirabari Moja in the district of Nogao, Assam. For Annexure C, photocopy of voter list of 1970 here that my own name is enlisted in the voter list of 1989, 80, 85 under.
It's not 85, this is 89. 85 your name is
80,
not there.
89 under 83, Hing LSC, so and so at village Durabundi, and I have cast my vote several times. But voter so that there is a land record in the name of my father of the opposite party, recorded as photocopy of land record enclosed herewith. That the SP border submitted the Hague report with a malified intention that I may post in to the foreigners tribunal for trial, causing me most financial as well as mental hardship. That under the contentions and documents annexed in the it can concluded safely that the answering opposite party is not at all foreigners, but an Indian citizen by birth. And as such, I have filled up my NRC form recently under the section the predator which is against me is required to dismiss a false and baseless, and I am acquitted and declared me as a citizen of India under receiving the WS and relevant documents which are submitted in support of WS. So this is the Sharafuddin, son of the Barlot. So I am just to satisfy Lordship as to whether I am the son of Jabbar. I am the son of Jabbar. That has been reflected in the voter list as well as also in our land records. This Sababandi. So when I can actually submit in a way that I being the son of Jabbar. So it is actually Jabbar, no dispute about Jabbar is the father of this Abul Kalam as well as Sharafuddin. So Sharafuddin and Abul Kalam being the son of Jabbar, they both received foreigners actually notice and they contested the case. However, they have approached came up to this Honorable High Court. Our High Court Lordship's division bench, after hearing at length of a particular case or one, decided the case in a way that found fit that it is not a fit, it is a fit case that they are the citizen of India and all that. So as regards the name of Mr. Jabbar, the present name of Sharafuddin, if I am actually in a position to satisfy your Lordship that Sharafuddin is a brother of Abul Kalam and at the same time son of Jabbar, then Lordship will be, I humbly submit before Lordship may be pleased to accept that contention. And in the same footing, law should be equal under equal circumstances, alike should be treated alike, Lordship, and Lordship may be pleased to express your contention.
Yes.
Page 30. Sworn on 3rd of May 2017. Stating that his age was 41 years at that particular date. So if we do a little bit of mathematics, then his date of birth will be 1976. So as Roxy has already pointed out, the first voter list that where his name has appeared, that he has submitted for the tribunal, is at page 34,
89.
voter list. So in 1989, this Sarafuddin, his age has been shown as 26, which is not possible. So in 1989, his age should have been 13 years, not 20. So this creates a doubt about the veracity of this voter. The only legal document that has been submitted is the government. The government certificate was submitted before tribunal, but it was not examined. Government was not examined, so it is not there. It cannot be taken into account. The Jamabandi copy. Now this Jamabandi copy was taken out in between 2016. So here, Jamabandi copy is at page 34.
Yes.
So here it is shown that serial number is Muhammad R. Jabbar, whom he is claiming to be the father. And the first father is Amiruddin. So this Amiruddin, whether this Jabbar is the same Jabbar of the voter list of 1965 and 70, we are not. Because father's name there,
Amir.
Amir and Amiruddin. there is some discrepancy, I'm just pointing out. Then lordship, this person, Sarafuddin's name appears at serial number 15
Yes.
towards the bottom.
Yes.
Now, this Sarafuddin, in his written statement, it is cross-examination. Cross-examination that
54.
54. 53 is the
English translation.
person. So here he says that my father expired in 1980. So in the Jamabandi copy, his father is shown as alive. I don't know, it may be, it's his document, he has to explain. It was taken in 2016, so it should have been updated up with the relevant information. I don't know whether it was not carried out or it's a different one.
Mr. Kolita,
Got
you come to page number 34,
Yes, sir.
you will see Kha. Kha is there. Kha.
On the
On the right hand side.
right
Or
column.
remark column.
Yes,
Montobo.
Oh, yes, sir.
Got it?
Yes, sir.
চিঠাৰ উপপতি সমহত্যাৰ 15/6/85 তাৰিখৰ হুকুম মতে 3 নম্বৰ স্থলত উত্তৰাধিকাৰী সূত্ৰে 13, 14, 15, 16 নম্বৰ নামে 90 নম্বৰ দাগে নামজাৰি হয়।
The order is not submitted by the
What was required,
1985.
what was required was that and revenue deposit certificate. And whether this document electronically updated.
And the specific order is also, if they are claiming that they have inherited, that specific order should be not part of.
What Mr. Huda has placed, a copy of the order of this court.
That I have gone through. I don't want to.
That's good. Thing is this, there the court, coordinate bench considered the federal list of 1985, where the name of the petitioner of that petition was at serial number 670. That's the federal list of 1985. Name of the present petitioner
No, not there.
is not there.
It's not there.
60, 670 is not there.
It's not there.
85 is also not there.
It's not.
Abul Kalam is there.
But that was not before the time.
85, the Abul Kalam case is distinguishable because 85 also Abul Kalam was there.
Correct.
And his age was 23,
Yeah.
Abul Kalam.
Cannot be, it is brother. Lordship, WS is totally vague. There is no statement and lordship, one thing I must point out. In the questioning by the court, tribunal, he could not answer anything. He could not answer anything. He did not name his grandmother also. He could not name his grandmother. I did not remember the name of my grandmother. I did not remember the date of year of my birth. Nothing. Only one date he has given that his father died in 1980 because he has brought in the voter list of 1989. So he has to give an explanation why his father's name is not there in any of the voter lists. So he comfortably given the date of 1980.
Who is Abdus Subhan?
Suhan. No, I am confined up to that Jabbar, father, and the
That is
sons.
the reason we are asking you.
That's it.
You relied upon a voter list of 1965 where you said your name of your father.
Abdul,
Page number 28.
page number 28, Jabbar.
Who is this
Amin.
Malika Khatun, wife of
Malika.
Abdul Subhan?
Malika Khatun. That part actually, Subhan or Malika Khatun, I am not.
There is a reason. That is the reason we are asking you.
Okay.
In your written statement, you are silent with regard to your siblings, with regard to the brothers and sisters of your father, your paternal uncle, aunt.
Grandfather.
something.
Most importantly, grandfather's name was also called.
Grandfather is also.
Ambika?
Who is Malika Khatun?
There is no Malika Khatun.
And who is this Subhan? But you resided in the same house. Your father was residing in the same house number 28 in the 1965. Serial number 240 and 241 at page 28. Now we'll tell you why this Abdul Subhan is required. Please come to deposition of DW3. Page number 60.
That's it.
Now, this Abdul Subhan, son of Abdul Subhan, Abdul Latif, he was DW3 in your case. He deposed, মই যি কম সঁচা কম, অপৰপক্ষ মোৰ ককাত বৰদেউতাৰ ল'ৰা, অপৰপক্ষৰ ভাই ককাই তিনিজন. So he is son of বৰদেউতা. That is the reason we are asking you who is this Abdul Subhan, whose wife Malika Khatun name figured with your father in the voter list of 1965. You have not explained anything in your written statement. See, naturally, you have to deduce who's an reliable and acceptable evidence.
No.
You have pick up a voter list from one area. You have pick up a land document from another area. Might be similar name also there.
What is the name of your mother?
Mother's name. What is it? Jamila Khatun. Daughter of no. Wife of Jabbar. Lordship. Jamila Khatun, page 43. Wife of A. Jabbar.
That's not on the basis of a certified copy of
That's
voter list.
voter list actually obtained from circumstance. Sorry. Lordship, as regards voter list, I humbly submit before your Lordship. Voter lists are distributed.
Jamila cannot be your mother. Jamila is the wife of A. Sattar. Come to page 31.
Jamila is a wife of Jabbar.
No.
Yes, for 43,
Come to page 31.
page 31.
Or at page 32. at
32
page-
the-
Jamila Khatun, Janaza Abdul Sattar.
Wife of A. Sattar.
Ah,
A. Sattar, and her age is also 25, matching with A.
A.
Sattar.
Sattar,
Sattar is
son of
22.
Jabbar.
Sattar is not your father. Your father, you have studied the age of birth.
There is one Jamina.
Huh?
And you cannot be,
Huh?
your age cannot be the more than your mother. You are 26, mother is 25.
Here 43, that is possible fine here. Jamila Khatun, wife of A. Jabbar, age of female, age 70. So 70.
40,
43.
43 is not a certified copy. We are.
These were not before the-
tribunal, these will not be voted.
90
cannot be-
93, the voter list was not there.
were not-
That is really circumstantial, Lordship.
And they cannot give me any record saying it like Abdul Kalam and Sarafuddin or father. No voter. There is no link of. that They are. Otherwise,
As to Jamamundi's copy, Annexure G, my learned friend used to convince the Honorable Court as to the relationship between actually Jabbar Sattar, Jabbar Kalam, Jabbar Sarafuddin, Jabbar Umbir, in which way he will answer this. He has shield of technicalities, find fault with the innocent, illiterate person who cannot write, unsophisticated class of people living in village, none to give them a correct advice. Where from photocopy is obtained, politically, socially, somewhere, voluntary voters copy are distributed to the Mandal Congress. Voters copy are distributed to the Block Congress. They are from the poor people, they extract the copy. That copy actually for easy access. It is so everywhere Dalal and forbid this extracting money from these poor people. How he has collected this voter list, I am concerned here before your Lordship will consider me. I crave your Lordship indulgence that as the brother of another Abdul Kalam, I am here before your Lordship to convince the Honorable Court that this Sita Jamabundi surveyed copy of certified copy that obliges us that his name appears there.
Can you show us that document is prior to 1971?
1971 document.
Is that prior to 1971 document or after 1971 document?
After 1971 document.
It is
Yeah,
prior
yes.
or after?
But here,
Despite of this Jamabandi, our honorable High Court, this
Mr. Hooda, Jamabandi of which year?
here it is shown 85.
Jamabandi of 85.
It is shown as per order dated 15/6/85.
So 85 is.
The names of serial number so and so are mutated in place of patta number 3 and so and so.
That is the reason we are asking you.
Yeah, I understand that the Lordship is explaining.
That is
very
the
much
difficulty.
trying to inquire into as to the veracity, whether it is right, real or correct or so and so. But at this, I humbly submit before Lordship that our division bench in the earlier case, while hearing possibly Sharafuddin, Abul Kalam, in his case, this part been required on possibly he has been able to satisfy this another advocate who was on record. Here I am just taking a privilege of having this certificate copy obtained from this High Court on division bench judgment, where the brother's case also, he is also languishing in such a situation. And that situation, Lordship may consider this aspect of whether it is similar to under analogous judgment, the same could have been disposed of, whether I am entitled to some benefit. Now, Lordship, if Lordship remands me alone to the tribunal for satisfaction of the tribunal, adducing some evidence before the tribunal, that may Lordship may so consider that I may again go to tribunal. The same document, same thing will be again before the tribunal. And then again, I shall have to come before your Lordship for another being discontented with any orders passed, to just pray before your Lordship for consideration. So whether Lordship has a feasibility, Lordship can at least consider the aspect of this present case as an analogous case. Son of a particular person, being the brother of a particular person, obtained the judgment order from this Honorable High Court as to the satisfaction that he is a citizen of India. Now, by his mother, his date of birth, his age, his a thumb impression he has placed.
Mr. Hooda, is there any evidence before the tribunal? Because the same tribunal which might have disposed of same tribunal, Morigaon tribunal.
Morigaon tribunal.
Fifth.
Which one?
Number 5.
Five.
Is there any evidence before the same tribunal that a similar case of his brother relating to the nationality is pending before the tribunal? Is there any evidence?
Lordship, in the Jamabandi copy,
Excuse me.
We would not have excused anyone else.
Lordship. It so happened. And yes, really. My memory is distracted day by day, Lordship.
Not at
Because
all.
since-
Not at all.
Since I have landed up to 89 on 27 March, 7 January. So since then, I find that I sort of memory. I cannot actually.
You're 89 years young.
I am landed to 89, 27.
89 years young, not
89.
old. Young,
So I
not
like to,
old.
in this case, today is all the brothers expired. There was actually function at my village home, Morigaon. I could not go because of this case. People are lamenting. And my new friend who are with this, they are not so intelligent to just place before Lordship of the case and all this. I don't know whether they will be account. They will come. So in this case, I have to be here with you before Lordship. I am obliged that Lordship has considered me as an aged person to be here.
No. We never said you are aged.
Lordship.
What brother is pointing out 89 year old,
Lordship.
young, not old, young.
Lordship.
53, here, his mother name is Tamina Khatun. And here in 31, Jamila Khatun. Sorry, Jamila Khatun.
Wife of Abdul Sattar.
Abdul Sattar. Jamila Khatun, wife of Abdul Jabbar.
Sometimes wrong, printed in printed form, sometimes wrong. But Abdul Jabbar, all things are, all these are, this sort of things are there, in that, all things, all the, this sort of cases, tribunal cases, voter list cannot be the guiding factor to by consider opinion. These are full of mistakes and all this wrong printing and all this.
Mr.
Jamila
Huda,
Khatun and Jamila Khatun
you are an
are different
experienced man,
persons.
both
Lordship.
in the legal field as well as the political field,
Lordship.
right? With the having experience in the political field and legal field, you know the voter list, right? The
Voter
Representation
list,
Act, you are
who is
fully
in the-
aware, it is have to be accepted in total.
It is
You
showing.
cannot have pick up from one from this, one from that, or is correction. That is why the procedures are there, not now. Since when the Representation of People Act is there is always a procedure for correction of name, address.
Correct.
The name of my mother is Jamila Khatun, not Jamila.
Kune দিছিলে কি?
This is
Sarafuddin. Lordship, page 50, Lordship, I have, again, I crave your Lordship indulgence. Lordship, page 53, a line actually I am just showing here. What is page 53 in the petition, this petition, in the last to the court, to court. This line is reading the entire.
Page 80.
53.
53, annexure O, the last to court. I did not remember in which year I cast vote. I did not remember the date and year of birth. I did not remember the name of grandmother. My father expired in the year 1980. The name of my mother is Jamila Khatun. I am having two elder brothers, namely Abdul Sattar, Abdul Kalam. The name of my elder
Sister-in-law.
sister-in-law is Jamila.
Jamila is mother's name.
Jamila.
Jamila is
Jamila is sister's name.
sister-in-law.
Sister-in-law.
Jamila and Jamila.
Jamila. This short.
In that case,
This sort of small lots of the differences are there here and their Muslim name some way. So it has become difficult. Nowadays, actually, the tribunal matters, when they are giving the evidence before the tribunal, they cannot speak a single word. Tribunal advocate, they guide them somewhere rather, and somewhere magistrate also, members of
DW3, can you come to page number 60?
60.
60. Evidence of DW3.
PW3.
DW.
DW3.
That son of Abdul Subhan.
Abdul Subhan. Abdul Latif, son of Abdul Subhan. This is another Abdul Subhan.
That's why I ask you, who is this Abdul Subhan?
Is the brother of Abdul Jabbar.
It is written here.
Abdul Subhan is the brother of Abdul Jabbar. Jabbar is the father. Father's brother Abdul Subhan.
Okay, listen to it.
This way.
মোৰ অপৰ পক্ষ মোৰ বৰদেউতাৰ ল'ৰা অপৰ পক্ষৰ ভাই ককাই তিনিজন এজন আব্দুল সাত্তাৰ এজন আব্দুল কালাম আৰু চাৰিফুদ্দিন অপৰ পক্ষ অপৰ পক্ষৰ মাৰ নাম জামিনা খাতুন প্ৰশিক্ষক ক এক্সিবিট এ ভাই ককাই আৰু মাকৰ নাম থকা 1985 চনৰ ভোটাৰ তালিকা
With humble submission, I am just making before Lordship will consider the aspect of just accepting the analogous judgment which has been actually voted by this honorable court, by the division bench. On the same footing, Lordship will consider the aspect of considering this a particular one person who is that say he is the son of so and so,
brother of so and so. It is not actually no doubt in this respect. And if required lordship so desires, I may ask them to produce another in a form of an affidavit to file an affidavit as to the veracity of this, what we have discussed in the before your lordship today. If so, advisable. And then that I am actually on the same footing, lordship will consider another in the same lordship's position. Actually, this has been heard in case of Abdul Kalam, and here this is Sharifuddin, who is the brother, and his matter is relating to all these same footing on same house, same mother, same father, same voter list, same place, and lordship will consider the aspect. Yeah.
Anything, Mr. Gupta?
Probably I was trying to show that because basically the case of American, that these things have been stuck up. I'm not speaking the 10%. Abdul Jabbar. You have that
Jamavandi, why it will go?
Jamavan should go for, first of all, he has not stated what is his father's grandfather's statement of grandfather. Now the voter list, two voter lists that he has submitted, Abdul Jabbar's father has been shown as one Amir. So we do not know whether this Amir and the person in the Jamavan whose name is Amir still at the same person. That situation should have come from with some document evidence that hasn't come.
Lordship, I guess I get taken interviews of a learned friend also. When I'm a learned friend from the side of the government, raising those sort of things, when Abul Kalam's matter was heard before the division bench, what failed them to, what caused them to fail this submission which they are making before your lordship? That could have been the same submission before that court also. Why they have ignored this that way? Now they are coming up with this, that poor man. When similar judgment has been given. Now all the fallacies are found actually from this name and birth and all these things. Why could not be registered against that person, Abul Kalam? Then it would be another issue that both the brothers could actually invoke the jurisdiction of some other court somewhere.
How do you know that this contentions were not raised?
Lordship,
how do you know that these contentions were not raised?
I don't know that thing because they are in this matter on a similar analogous case.
Now, how do you know that these contentions were not raised in the earlier case? You were not there.
No, here that was not recorded.
No, you were not the counsel. So how do you know what contentions they had raised?
No, what they have done, I don't know. But I am saying so.
Maybe they have raised more objections.
If you have submitted in that case before the another actually August court, then here you are submitting all right. But you could not resist that. Abul Kalam has got the citizenship.
No, how do you know that whether he had resisted or not?
That part I do not know. I humbly
We
apologize if I hurt all of you. But my contention is this: I am to give a praying before your receipt to give a relief to these poor people for this part of life.
Definitely consider.
That's all.
See, the Jamabandi,
That's all.
this no doubt is of 2016.
Correct.
The takes into consideration of an order of 1985.
Yes.
And the statement is there that the father had passed away in 1980. So in place of the father, names of the petitioner and his projected brother has come up.
But like his name was not struck down, if your
Oh,
lordship
His
notices.
name is struck down.
Abdul Jabbar is still there. Lordship may see his name. Abdul Jabbar is still there. It is a document of 2016.
Just a minute. Where? Abdul Jabbar.
Page 34, Lordship, on the left hand side,
No.
on the top. Number
Number-
number three. His name is not struck down. Other names, certain other names have been struck down.
Oh, so it's not struck off.
It's not struck off. So if it's a document of 2016, and if it's in
Right.
case of inheritance, then his name should have been struck off from there. And the inheritor's name should have been there. Inheritor's names are there.
Sharma.
And there is, Lordship, there is no document to show that Abdul Aziz is the son of Amiruddin. So we don't know the veracity of this Jamabandi, how it has been done.
Mr. Kolita, just take.
Yes, sir.
Yeah. How much more? Muri ko muri. Mati kita na. Kale mama. Enteni koi chila na. Kakul lagi na. Lahori.
Let's be another, pointing out. Lordship, kindly peruse this page 38, where Gambura certificate is specified that all there. This is also another important document here in this petition. Page 38 is Gambura, government Gambura, whose FSC is still and all this. In the FSC case also, it was actually, he was reduced evidence and all that. Yeah, Sharif, son of Abdul Jabbar.
This Gambura was witness number?
What?
Witness number?
Witness number, Manson?
Author of the document was not examined.
FTC case still mentioned. Oh, FTC has affixed seal, and all these are this exhibit. It has been exhibited also there.
By whom?
Yeah, that tested at that part. I don't know.
Author has to be examined.
Okay.
Or at least some authorized person from the office.
That part I do. SE. These are all.
Kami koi.
Right.
Ano pa? Na ito. Not only 2013 no. Ibu pernah because of this. 2013 or gimana? number 90. Not 50%. 91. Thank you. Ninety-one, right? 92. 91 mana, right? 92. One 30. Itu apa no? Mr. Kolita, we tried with the Dharitri app. We tried with the Dharitri app. Then this Morigaon, then Laurigat Circle, Durabandi Gaon. This all the products data are not able. We have tried again, we tried. Yes, sir. 1991. Okay. A9, A0, 9, A0. D9H, M6, H. Duravan. Nine.
It's difficult to understand, Lordship, how they have procured.
No, no, now it is not available.
Maybe.
Now the data may not
Maybe.
be available, there it may be available.
Maybe.
Heard Mr. Yasuda. Not counsel for the. Sorry, Philippa. The council form for the number. Madhurika. S. Madhurika. H. Madhurika. 2 minutes. Come for it. Take it for it. Active is the technique for 4 to 6 of 16 people step 5. Wherein the input of 30 past involved in